Hello, my name is Ira Smith, President of Ira Smith Trustee and Receiver, Inc. First of all, Brandon Smith, myself, and the entire Ira Smith team hope that you and your family are safe, healthy, and secure during this COVID-19 pandemic and emergency shutdown. There's a lot of talk in the media about all the economic carnage and fallout from the shutdown of the Canadian economy. We've already seen in the United States many huge retailers filing for bankruptcy protection, and we are starting to see it in Canada as well. Everyone is scared. Businesses are shut down. Jobs have been lost. Nobody knows how this is all going to end. The only thing we know for sure is that there was a lot of pain and suffering right now, and that there is going to be a lot of financial problems coming out of this. So today's Brandon's blog is our top 6 things that creditors must know about the Canadian bankruptcy process. It will be very important for creditors to understand what their rights are in dealing with people and companies that are in financial distress. So, I hope you can watch this whole video. I know you will get value from it. The first thing that creditors should know about bankruptcy in Ontario and Canada is that for a filing under the Bankruptcy and Insolvency Act, whether it is bankruptcy, consumer proposal, a larger Division 1 restructuring bankruptcy protection proposal, or a notice of intention to make a proposal, there is an automatic stay of proceedings. The debtor is automatically protected. Creditors cannot begin or continue collection or enforcement action. Now, in a private receivership, there is no stay of proceedings. However, in either a court-appointed receivership or a large restructuring under the Companies Creditors Arrangement Act, there is a stay of proceedings, but it is not automatic. It doesn't happen because someone has made application to court. It happens by way of the appointment order. Standard in every appointment order of a court-appointed receiver or a monitor under the CCAA is that there will be a stay of proceedings section ordered by the judge. Now, there are rare circumstances where a stay of proceedings can be overturned in unique circumstances. The only common one is that if a secured creditor goes to court and says, I will never ever support any restructuring whatsoever, no matter what it says, let me take possession of the assets covered under my security, and I will go deal with them myself because that is my right. That is a very persuasive argument for the court. Failing that, there will be an automatic stay of proceedings. Our second tip is to know what kind of proceeding your customer has filed, and to know when it is important for you to file a proof of claim and how to complete a proof of claim properly. When you get notice from the licensed insolvency trustee, you will see in the notice, it will tell you what kind of proceeding it is. Is it a bankruptcy? Is it a proposal? An attempt to restructure? In either a bankruptcy or a proposal under the BIA, there will be a proof of claim form. It is important to know how to fill it in and when to submit it. If all you want to do is be in line to receive any potential dividend, but you have no interest in actively participating in the administration of the bankruptcy or proposal restructuring, and you don't care to vote on any matters, then you just need to file the proof of claim before the licensed insolvency trustee sends out the final distribution. And if you're on the original list of creditors, which you would be if you got the original notice, and you haven't filed the proof of claim and the trustee is ready to do a final distribution, the trustee has to send you a notice to let you know that if you don't file your claim, you will be barred forever. However, if you wish to participate actively, you wish to vote, you wish your voice to be heard, then you have to file the proof of claim within a certain time frame, which is before the first meeting of creditors in a bankruptcy starts or before the meeting of creditors in a proposal starts. That will give you status to attend the meeting and to vote on all matters. Our third tip for creditors is, what if you know that your customer is in financial trouble and is probably going to go bankrupt, and you have been able to exert enough pressure on them that they pay you off either partially or in full? Should you take the money? Definitely take the money. It may be a preference payment, and if there's a bankruptcy, the licensed insolvency trustee may very well be able to attack you for having received the payment as a preference. If a payment is made to certain creditors on the eve of bankruptcy, there is already a presumption of a preference. And if the trustee attacks the transaction to get the money back from the creditor, the presumption is there, and it is up to the creditor to rebut that presumption. And there are only a few bases that you can rebut that presumption on. It's fairly narrow. But maybe, for whatever reason, the trustee's review of the books and records does not alert the trustee to the payment. Or perhaps you will be able to reach a settlement on the preference and pay the trustee less than 100% that you've received. But in all cases, better to have the money in your pocket. It is not a crime. It is not immoral. It is not unethical to collect from your customer. Just keep in mind, you may have to fight for it later on if there is a bankruptcy. Our fourth tip is to read the documentation you get from the trustee very carefully, whether it's a bankruptcy, a proposal, a receivership. Especially in a bankruptcy or proposal, the trustee needs to alert creditors to any issues that have arisen in the bankruptcy administration, such as preference payments that may have been made or actions that the trustee could take to recover money if only the trustee had the funds to pay for it. In that case, the trustee will advise the creditors one of two things: either that the creditors can fund the trustee for the trustee to take action, or creditors can go to court and try to get an order under Section 38 of the Bankruptcy and Insolvency Act to take on that action in their own name. And if the trustee is either unable or unwilling to take specific action, then a creditor or group of creditors will be able to get that order under Section 38 of the Bankruptcy and Insolvency Act. A trustee probably would not be funded by creditors to do the action itself, because the creditors would be paying 100% of the costs to then only share in any recovery ratably with all the other unsecured creditors. So from a creditor standpoint, it doesn't make sense. But a creditor may want to take action under Section 38 because if the creditor is successful in the action, then the creditor's recovery first goes towards the cost of the action. The next part of the recovery goes to satisfy that creditor's claim in full, and only if there's money left over afterwards, then that money has to be paid over to the trustee. So an astute creditor looking at a potential action and determining that there's a high likelihood of success might want to take that on in order to recover more money for themselves than they otherwise might from the bankruptcy itself. Our fifth tip about bankruptcies in Ontario and Canada that creditors should know, that in a personal bankruptcy, the bankrupt getting his or her discharge discharges that person from all of their debts with extremely few exceptions. Brandon has written blogs in the past about the exceptions under Section 178 of the Bankruptcy and Insolvency Act, which is a very narrow list of the kinds of debts that are not discharged. So things like alimony support, court fines, debts that have arisen from fraud or fraudulent misrepresentation are the common ones. Many creditors claim they have been defrauded, but you have to actually prove it. The time to prove it is not in opposing the bankrupt's application for discharge. You have to have had a fraud finding in court suing on your debt in order to establish fraud. In a bankruptcy, as I mentioned, there's an automatic stay of proceedings. But if you're alleging fraud, the court will lift the stay of proceedings to allow you to go to court to litigate on the aspect of whether a fraud has been committed. And if you are successful in getting a judgment indicating that there was fraud and therefore that debt, your debt, is an amount that falls under Section 178 of the Bankruptcy and Insolvency Act and is not released by an order of discharge, then you have proven fraud. And moreover, you will want the bankrupt to get their discharge as quickly as possible, because then they will have been discharged from all of their other debts, and the only debt remaining is yours. And you will then be able to hold that judgment, that debt, over the debtor's head after bankruptcy discharge for as long as it takes until you get paid off. Our sixth tip is that in a successful restructuring, whether it is a proposal under the Bankruptcy and Insolvency Act or it is restructuring, corporate restructuring under the Companies Creditors Arrangement Act, that releases the debtor who has successfully completed their proposal from all of their debts. Like, you may think that because you're holding a personal guarantee from the shareholder or directors that you are safe. But no, if the corporate debt has been discharged through a successful proposal, then there is no debt left for anyone to guarantee. So you've lost the ability to go against the guarantor also. And here's a seventh bonus tip for you. It is better to get professional advice on how to structure the credit you are going to grant to your customer before you grant the credit. The professional advice after your customer has already filed for bankruptcy or proposal, by its very nature, because of the circumstance, is going to be very limited. So the best time to best protect yourself against the likelihood of bankruptcy or proposal by one of your customers is before you actually grant the credit. I hope you've enjoyed this video. Please read the full Brandon's blog underneath me. Again, stay safe, stay healthy, stay secure, you and your family. Brandon Smith and myself are available during this entire pandemic shutdown to answer any questions that you might have. We are answering questions and holding meetings by telephone or video conference. So please shoot us a message, give us a call, arrange a video meeting. We will be thrilled to speak with you and answer any questions that you might have.